Doctrine of ultra wires. What is ultra wires? Ultra means beyond and wires means power. So anything which is beyond the power. So ultra wires act are acts which are beyond the powers of the company. Okay. A company should confine its activities within stated objects. Okay. Whatever are the stated objects, the company should do its activity within these objects. It should not go beyond these objects. Okay. It restricts the powers of company to go beyond its objects clause. Okay, whatever is stated in the objects clause, the company should do activities within those objects clause. Act which is ultra vires is void and does not bind the company. Neither the company nor the contracting party can sue each other. Okay, if there is any act which is ultra vires, which is beyond the power, okay, it is void, it is valueless, and that act will not bind the company. Okay, the company will not be liable for that act. Neither the company nor the contracting party can sue each other. They cannot take legal action against each other. Ultra vires act cannot be made valid by ratification even by all the members. Okay, if there is an ultra vires act, if there is an act which is beyond the stated objects which is beyond the power of the company, it cannot be made valid. Okay, it cannot be made valid by approval of even all the members. Even if all the members approve it, then also that act cannot be made valid. Ultra vires act is void. There is a case law, Ashbury Railway Carriage and Iron Company versus Rish 1875. The objects clause of memorandum of association of the company, the in the memorandum of association of the company, the object clause said that the objects of the company were to sell or lend on hire railway carriages and wagons and all kinds of railway plants, etc., and to carry business of mechanical engineers and general contractors. Okay, these were the stated objects in the object clause of memorandum of association of the company. Okay, this company entered into a contract with Rish, a firm of railway contractors, to finance a railway line in Belgium. Okay, this company did a contract with Rish to finance a railway line in Belgium. The company, however, repudiated the contract. Okay, it rejected the contract, it denied the contract on the ground that it is ultra wires. Okay, the company said that this contract is beyond our power, beyond the objects stated in the object clause of memorandum of association. Okay, so what the Rish did, Rish brought suit for damages and breach of contract. Okay, the Rish took legal action against the company. And what was the contention of Rich? What did he said? He said that the contract was well within the term general contractors. Okay, the Rich said that the contract is within the term general contractors. The contract come under this term. Okay, used in memorandum and therefore within company's powers. So if the contract is in within this term, then it comes within the objects clause of the memorandum of association, so it is within company's power. This was the contention of Rish. That apart, he said that the contract was ratified by majority of shareholders, that the majority of shareholders, they ratified the contract. Okay, but the House of Lords said that the House of Lords ruled that the contract was ultra vires, therefore null and void. The House of Lords said that the contract is beyond the powers or beyond the objects stated in memorandum. Okay, it is beyond the power of the company to make such contract. Lord Keynes observed that the term general contractors must be taken to indicate contracts connected with the business of mechanical engineers. Okay, Lord Keynes said that this term general contractors, it is connected with this term mechanical engineers. If not so interpreted, okay, if this term general contractors is not interpreted like this, then it will authorize making contracts of any and every description, virtually point to carry business of any kind whatsoever. Okay, if it not if it is not interpreted like this, then the term general contractors, it will authorize the company to make contracts of any and every description. Okay, and the company will do any type of business, it can carry any type of business. So but the company has to state specifically what are its objects. Okay, if it starts doing any type of business, if it starts making contracts of any kind, then they will go outside the scope of the company, outside the scope of the objects stated. Okay, so hence the contract was beyond objects in memorandum. Okay, it cannot be interpreted like this. General cannot be interpreted like the company can make any type of contract. The company can make only those type of contract which are in the objects clause. Okay, so the term general contractors is connected with the previous term mechanical engineers. Okay, only the business which is related to business of mechanical engineers. Therefore it is beyond power of company to make such contract. What activities are valid? Suppose the activities which are essential for the fulfillment of objects. Okay, stated in main objects clause. Suppose there are some activities which are stated in the main objects clause. Okay, so if we do any activity which is not mentioned in memorandum of association, but it will be valid if that activity is essential to fulfill the objects stated in the main object clause. Okay, the activities which are incidental and consequential or reasonably within its permissible limits of business. Okay, so if you are doing the activities which are permitted, and as a result of these activities some acts happen or some activities happen, or there is some result, that result is also valid. Okay, if even if it is not mentioned in the memorandum, and that act should also be authorized, the company should be authorized to do by Companies Act. That act should also be authorized by the Companies Act. If any act is not authorized by Companies Act, then it will not be a valid activity, it will be an invalid activity. So what are the exceptions? It means what type of activities which even not mentioned in memorandum of association or the objects clause. Okay, what are the stated objects? If the activities is not mentioned in those permitted activities, even then it is allowed. What type of exceptions are allowed? Act intra vires but outside directors authority, shareholders can ratify it. Suppose there is an act which is intra vires, which is within the powers of the company, but outside the authority of the director some does some act which is outside his authority but which is within the authority of the company, then the shareholders can ratify it, they can approve it. If an act is intra vires but done with irregularity, the shareholders can ratify. If there is some act which is intra vires, which is within the powers of the company, but it is done with irregularity, that act can also be ratified by the shareholders. It will be made valid by ratifying. Okay, the company acquired property through ultra vires investment, that property will be secure. Okay, suppose the company acquires some property, but the investment is but the acquiring is through ultra vires beyond power investment. Okay, then also the property will be secure, there will be no problem. Effects which are incidental or consequential to act. Okay, which we have already discussed, they are not invalid unless expressly prohibited by Companies Act. If there are some act which are permitted within the objects clause, and as a result of this act some act happens which is not mentioned in the memorandum or the objects stated, okay, objects of the company, then this act is also valid because it is in consequence of the valid act. Certain acts under Companies Act, though not expressly stated in memorandum, are impliedly within authority of company, therefore deemed not ultra vires. There are certain acts given in Companies Act, though they are not expressly stated in the memorandum, but they are impliedly, indirectly within the authority of the company. The company can uh, do those acts, do those activities, even though they are not expressly stated in memorandum. Why they can do it? Because they are allowed in Companies Act, therefore they are deemed not ultra vires. Okay, they are not ultra vires. If act is ultra vires articles of association, the company can alter its articles to validate that act. Suppose there is an act which is beyond the power of the articles, okay, which is beyond the objects stated in the articles, that type of act the company can validate by changing the articles. Okay, it is not as difficult as memorandum because there are more formalities and restrictions in memorandum. It is not so in the case of articles. The articles can be changed to make that act valid. What are the consequences of an ultra vires act? If any ultra vires act happens, what will be the consequences? Injunction. Members can get injunction to restrain company. The members can get an order to stop the company from doing that act, from prevent the company from doing that act. Okay, the directors are held personally liable. If directors do some ultra vires act, they are personally liable. Okay, breach of warranty. Directors being agent of company can do nothing which the company itself cannot do. Okay, the directors are agent of the company. Okay, directors can do only those things which a company can do. If and there is anything which the company cannot do, the directors can also not do that thing. If the directors are doing that thing which the company cannot do, then it is a breach of warranty, which breach of authority given to the directors. Okay, the property acquired through Ultra Vires Act, it is secured. We have already discussed it before. If any property is acquired through Ultra Vires Act, it will be secured. Okay, there is no problem. Ultra Vires contracts are void ab initio. Okay, if there is any contract which is Ultra Vires, which is beyond the power, okay, the company cannot make that contract. Even then the company is making that contract, that contract is void ab initio. It is useless. It is valueless initial initial. Okay, from beginning. Liability under law of torts. Okay, what are the liabilities if any tort happens? There is uncertainty about the extent company is liable for damages resulting from ultravires act. If some ultravires eh, due to some ultravire acts some tort happens, then the how much the company will be liable for damages, there is uncertainty. It is not certain, but the company will be liable if the act is within memorandum of association. Okay, any act which is within memorandum of association, and due to that act some tort happens. Okay, there is some loss, then the company will be liable. And or the tort committed by a servant within scope of his employment. If there is any tort done by any committed by any servant, which is the servant did that act within the scope of his employment during his employment, then the company will be liable for it. Okay, so this was ultra wires act. If you want the PDF for revision purposes, okay, you can get it from you can get the download link from the description box or the comment box. If you are interested, you can get it from there. Next we will see doctrine of constructive notice in next video.